For years, I believed my vacant property was exactly what it looked like on paper, mine. I paid the property taxes every single year. I maintained the boundary markers. I kept copies of every survey, every deed, and every document connected to that land. It wasn't my primary residence. It was a long-term investment I planned to develop when the time was right. Because I lived several hours away, I only visited every few weeks to check on it. Nothing ever happened there. It was quiet, peaceful, and untouched. That was exactly why I never imagined someone would have the confidence to start building an entire house on it without even asking for permission. One Saturday morning, I decided to drive out to inspect the property after receiving a vague message from a nearby resident. He didn't explain much over the phone. All he said was, "You should come see what's happening on your land." His voice sounded concerned enough that I left immediately. During the drive, I convinced myself it was probably nothing serious. Maybe someone had dumped trash. Maybe kids had driven ATVs across the field. I certainly wasn't expecting what I found. The moment I turned onto the gravel road leading to my property, I noticed heavy construction equipment. There were pickup trucks lined up along the edge of the road. Fresh tire tracks covered the entrance. I slowed down, confused. As I got closer, I saw workers wearing reflective vests. Excavators were digging trenches. Concrete forms had already been placed. Lumber was stacked in neat piles. Someone had cleared nearly half an acre of my land. It looked like the beginning of a brand new residential construction project. At first, I honestly thought I had taken a wrong turn. I checked the GPS. I checked the survey map stored on my phone. I looked at the old oak tree near the entrance, the creek running along the eastern boundary, and the survey marker I personally watched being installed years earlier. There was no mistake. This was my property. Workers were actively building a house on my land. I parked my truck and walked directly toward the construction crew. One of the foremen approached me before I even reached the foundation area. He asked if he could help me. I pointed toward the cleared lot and calmly asked who had authorized this construction. Without hesitation, he replied that the project belonged to the homeowners association for the neighboring subdivision. According to him, everything had already been approved and construction had been underway for almost 2 weeks. I stared at him for several seconds. Then I asked the simplest question possible. "Do you know who owns this land?" He answered confidently, "The HOA." That one sentence told me something had gone terribly wrong. I calmly introduced myself as the legal owner. The foreman's smile disappeared instantly. He looked back toward the partially completed foundation, then back at me, almost waiting for someone to tell him I was joking. I wasn't. He immediately called his project manager. Within 15 minutes, 2 men wearing company polo shirts arrived. One introduced himself as the site supervisor. The other said he represented the HOA's development committee. Instead of apologizing, they immediately insisted they had every legal right to build there. They claimed the subdivision expansion plans clearly showed this parcel as future HOA property. I asked them one question. "Can you show me the deed transferring ownership?" Silence. Instead, they unfolded several construction drawings, blueprints, subdivision layouts, future development plans, everything except the one document that actually mattered. A deed. I explained that engineering plans don't transfer ownership. Construction permits don't transfer ownership. HOA maps don't transfer ownership. Only a properly recorded property deed does that. They kept insisting their legal department had already handled everything. I told them I had never signed a single document. Not one. The conversation quickly became uncomfortable. The site supervisor quietly admitted he had never personally seen any ownership paperwork. He simply relied on what the HOA provided before beginning construction. That was my first clue that even the builder had been misled. I left the site without arguing further. Instead of making emotional decisions, I drove straight to the county recorder's office. Within 30 minutes, I had certified copies of every recorded document affecting my parcel. The results were exactly what I expected. My name remained the only legal owner. No transfers, no easements allowing residential construction, no sales, no condemnations, nothing. Legally speaking, absolutely nothing had changed. Yet somehow an entire construction project had already begun. The next stop was the county planning department. I wanted to know how permits had even been issued. The employee searched the permit records. She looked confused almost immediately. The permits referenced an entirely different parcel number. One digit had been entered incorrectly during the application process. That single clerical mistake pointed the construction approval toward HOA-owned land located several hundred feet away. The actual construction site, however, sat entirely on my property. Nobody had verified the physical location before excavation began. One small paperwork error had triggered a massive legal disaster. I asked whether that mistake allowed construction to continue. Her answer was immediate. No. She explained that permits only authorize work on the approved parcel. Building anywhere else invalidates the authorization. That meant the foundation, excavation, grading, and framing already completed had no legal protection whatsoever. I requested written confirmation. She printed the records. I thanked her and left. The following morning, I hired a licensed land surveyor to perform an emergency boundary verification. By midday, bright orange stakes marked every corner of my property. The survey crew also installed highly visible ribbons showing the exact boundary lines. There could be no confusion anymore. When construction resumed Monday morning, workers discovered survey markers running directly through the middle of the newly poured foundation. Several immediately stopped working. Others called their supervisors. Within an hour, the HOA president arrived. She walked across my property as if she owned every inch of it. Without introducing herself, she declared the survey had to be wrong. She insisted the neighborhood expansion plans proved otherwise. I handed her certified copies of the recorded deed. She barely looked at them. Instead, she repeated that the HOA's attorneys had already reviewed everything. I simply asked one question. If your attorneys are so confident, why didn't anyone contact the actual owner before spending hundreds of thousands of dollars? She had no answer. Instead, she accused me of interfering with community development. That accusation was almost unbelievable. Someone was building on my land without permission, yet somehow I was the problem. I told her politely but firmly that all construction needed to stop immediately. She refused. She claimed stopping work would cost the HOA too much money. At that moment, I realized something important. They weren't acting out of legal confidence. They were acting out of financial panic. Every additional day of construction increased their losses if they turned out to be wrong. Unfortunately for them, they already were. Instead of arguing any further, I contacted a real estate attorney who specialized in property disputes. After reviewing my documents for less than an hour, he looked up and smiled. Then he said words I'll never forget. They don't have a property dispute. They have a trespassing problem. That single sentence completely changed the direction of the entire case. Rather than debating ownership, we focused on unlawful entry, unauthorized construction, property damage, and continuous trespass. My attorney immediately prepared formal legal notices demanding every worker, contractor, subcontractor, and HOA representative vacate the property immediately, preserve all evidence, and cease every construction activity until further court action. The notices were delivered that same afternoon. Every contractor received a copy. The HOA board received one by certified mail and another by personal delivery. The construction company received one at its headquarters. Even the project engineer was notified. There would be no excuse for claiming they didn't know. From that moment forward, anyone who continued working on my land would be doing so with full knowledge that they were trespassing. That changed everything. I expected construction to stop the next morning. It didn't. When I arrived just after sunrise, I could hear nail guns echoing across my property. Workers were unloading roof trusses. Concrete trucks were backing toward the foundation. It was as if they had completely ignored every legal notice we had sent. I parked where everyone could see me. Several workers recognized me immediately. One of them quietly walked over and admitted they had been told to continue because the lawyers would handle it later. That statement shocked me. Someone had decided it was cheaper to keep building and deal with the consequences afterward. My attorney had warned me this could happen. Some organizations convince themselves that finishing the project creates leverage. They hope the property owner will eventually accept a settlement instead of forcing demolition. But the law doesn't reward someone for building first and asking questions later. I didn't argue with the crew. Instead, I documented everything. Every truck entering the property. Every worker on site. Every pallet of materials. Every minute construction continued after legal notice had been served. The survey markers remained untouched, standing only a few feet away from active equipment. No one could honestly claim they didn't know they were crossing a property line. Around mid-morning, my attorney arrived carrying a thick folder. He walked directly to the site supervisor and handed him another document. This one wasn't just a warning. It was a formal demand to cease trespassing immediately. The supervisor read the first page, looked toward the partially framed structure, and quietly stepped away to make a phone call. Within 20 minutes, several expensive SUVs pulled onto the property. The HOA president stepped out first. Behind her came two board members and an attorney representing the association. Unlike our previous conversation, they weren't smiling anymore. Their attorney asked if we could speak privately. My attorney refused. He said every discussion would happen in front of witnesses. The HOA attorney started by claiming there had been an administrative misunderstanding. My attorney interrupted him. No, he said calmly. This isn't an administrative misunderstanding. Your client entered private property, removed vegetation, excavated soil, poured concrete, and began constructing a residence without ownership. The atmosphere changed instantly. Nobody wanted to argue over facts anymore. Instead, they began talking about possible solutions. The HOA president suggested purchasing my property. I laughed. Not because selling was impossible. Because they were only interested now that they had already damaged the land. I asked what they would have done if I had never shown up. No one answered. Instead, they offered what they called a generous price. It wasn't generous. It wasn't even close to market value. In fact, it was lower than what similar undeveloped parcels had sold for the previous year. Apparently they believed I would panic and accept quick money just to avoid court. They had completely misjudged me. I declined immediately. The HOA president became visibly frustrated. She argued that the house was already halfway complete. I reminded her whose decision that was. Not mine. Every dollar spent after they entered my land had been their choice. The consequences belonged to them as well. The board members whispered among themselves. Their confidence from a week earlier had completely disappeared. They had gone from claiming absolute ownership to trying to negotiate a purchase in less than 48 hours. That told me everything I needed to know. They finally understood the seriousness of their mistake. By the end of the meeting, construction finally stopped. Workers packed up equipment, power tools went silent, heavy machinery rolled toward the exit. For the first time since discovering the project, my property was quiet again. But the damage remained. Fresh concrete sat across my land. Excavated soil had changed the natural drainage. Trees that had stood there for decades were gone. The value of restoring the property would not be small. Over the next several days, our legal team hired independent experts. A licensed appraiser evaluated the loss in property value. An environmental consultant inspected the disturbed land. A civil engineer documented grading changes and drainage issues. An arborist calculated the replacement cost of mature trees that had been removed. Every report added another layer to the potential damages. The numbers climbed rapidly. Then something unexpected happened. One of the subcontractors contacted me privately. He asked if we could meet away from the construction site. Curious, I agreed. He arrived carrying a binder. Inside were copies of emails, internal work orders, and meeting notes. According to him, several people inside the construction company had questioned the property boundaries before work even began. One survey technician reportedly warned management that the legal description didn't match the physical staking on the ground. Another employee recommended delaying excavation until ownership could be confirmed. Neither warning was followed. Instead, management instructed everyone to proceed because the HOA insisted the issue had already been cleared by legal. The subcontractor told me he came forward because he didn't want his company blamed for decisions made above his level. Those documents became some of the strongest evidence we had. They suggested that warning signs existed long before the first shovel entered my property. Someone had chosen to ignore them. A week later, the county building department conducted its own inspection. Inspectors walked every corner of the site with measuring equipment, permit files, and survey maps. It didn't take them long to reach the same conclusion we already knew. The structure wasn't simply close to my property line. It was entirely on my land. Not a few feet, not a few inches. The entire footprint of the future home sat within my legal boundaries. As the inspectors marked their findings, I noticed something unusual. The HOA president wasn't speaking anymore. She stood quietly near her vehicle, watching every measurement being taken. The confidence she had displayed on the first day was gone. Now she seemed more concerned about what the official reports would say than about defending the project. Then one inspector unfolded a large county plat map beside the foundation, compared it with the GPS survey data, and called the rest of his team over. They spent several minutes pointing at parcel numbers, boundary lines, and permit references before one of them slowly shook his head and reached for his radio. The inspector's voice was calm, but every word carried weight. He requested a supervisor to come to the site immediately. That wasn't something inspectors did for routine paperwork. Whatever they had discovered was serious enough to require another level of review before anything else happened. About 40 minutes later, 2 county vehicles pulled onto the property. A senior building official stepped out carrying a large binder containing permit records, zoning maps, and recorded plats. He spent several minutes comparing every document with the survey stakes surrounding the construction site. Then he walked the entire perimeter himself, measuring distances from multiple reference points. When he finished, he didn't speak to the contractors first. He walked straight toward me. He introduced himself, shook my hand, and said, "Based on everything we've reviewed so far, you appear to be the legal property owner." Those words echoed across the construction site. Several workers stopped what they were doing just to listen. The HOA president immediately interrupted. She insisted the county records hadn't been updated after the subdivision expansion. The official looked directly at her. "We've checked the current records." She tried again. "Our attorney has different information." The official answered without raising his voice. "County ownership isn't determined by opinions. It's determined by recorded documents." That ended the argument. The contractors understood exactly what was happening. Within minutes, equipment operators began shutting down their machines again. They weren't willing to continue once county officials openly questioned the legality of the project. The senior inspector then did something I had been hoping for since this nightmare began. He issued an official stop work order. Bright red notices were attached to the partially completed structure. Another notice was placed near the entrance to the property. Copies were handed directly to the site supervisor. From that moment forward, no additional construction could legally occur without violating a county order. The atmosphere changed instantly. Workers started packing tools into trailers. Material deliveries that had been scheduled for later that day were cancelled over the phone. Drivers arriving with roofing supplies turned around before entering the property. The entire project froze in place. For the first time in weeks, nobody was building on my land. I should have felt relieved. Instead, I looked at the unfinished structure sitting in the middle of my property and realized the hardest part was still ahead. Stopping construction was only the beginning. Now someone had to pay for everything that had happened. Over the following days, our legal team filed a civil lawsuit. The complaint covered trespass, property damage, unlawful occupation, negligence, and restoration costs. It also requested compensation for every expense I had been forced to incur because of the unauthorized construction. When the HOA received the lawsuit, they responded exactly as many people expected. They denied responsibility. According to their official filing, the construction company was responsible. A week later, the construction company filed its own response. They blamed the HOA. Then the engineering firm submitted its answer. They blamed incorrect information provided by the HOA. Soon afterward, the surveying consultant argued they had only marked locations described in documents they received. Everyone was pointing fingers at someone else. Nobody wanted to admit who made the original decision. Fortunately, documents don't play that game. Our attorney began collecting contracts between every party involved. The construction agreement, the engineering contract, meeting minutes from HOA board sessions, internal emails, invoices, approval forms. Every signature mattered. Every date mattered. Every email created another piece of the timeline. During discovery, we finally received thousands of pages of internal communications. Buried deep inside those files was an email chain that immediately caught my attorney's attention. The subject line read, "Property ownership concern." That alone was enough to make us stop reading everything else. The first email came from a junior project coordinator. He questioned why no title report had been completed before construction started. Another employee replied that obtaining one would delay the project by several weeks. Then came the message that changed everything. A board member responded, "We've already invested too much time. Move forward." Another email followed only minutes later. "If there's an ownership issue, we'll deal with it afterward." My attorney printed that page in color. He highlighted those two sentences. Then he looked at me and smiled. They knew there was a risk. That single email transformed the entire case. This was no longer simply an unfortunate mistake. It suggested conscious disregard for property ownership. In other words, someone had been warned. Someone understood the risk. Someone chose to continue anyway. As word spread through the neighborhood, more people started contacting me. One homeowner admitted she had questioned why construction crews were working outside the subdivision boundaries. Another neighbor recalled asking an HOA board member whether they had purchased the land. She was told everything had already been finalized. An elderly resident even showed me photographs he had taken weeks before construction started. The pictures clearly showed my original survey markers still standing before excavation began. That destroyed another possible excuse. No one could honestly claim the property boundaries were impossible to identify. The evidence continued growing. Then another surprise arrived. A former HOA board member reached out through my attorney. He had resigned months before construction began but still possessed copies of old meeting notes. According to him, my parcel had been discussed during several planning meetings. The board wanted the land because it was perfectly positioned for expanding the neighborhood entrance. Someone suggested approaching me with an offer. Another person suggested negotiating an easement. But according to those notes, no agreement was ever reached. Instead, the subject quietly disappeared from later meetings. Months later, construction suddenly began. Those notes raised a troubling question. If they knew they never bought my property, why did they act as though they owned it? As depositions began, executives from the construction company testified under oath. The site supervisor admitted he never verified ownership personally. The project manager acknowledged relying entirely on documents provided by the HOA. The engineering consultant confirmed they never performed an independent title search. One by one, each witness described a process built almost entirely on assumptions. No one checked the deed. No one contacted the owner. No one compared the legal description against the physical construction site until after excavation had already begun. The pattern became impossible to ignore. This wasn't one person's mistake. It was a chain of shortcuts. Each shortcut seemed small at the time. Together, they created one of the biggest property disputes the county had seen in years. Then came the deposition everyone had been waiting for. The HOA president entered the conference room accompanied by 2 attorneys. She looked confident at first. Our attorney started with simple questions. Her name, her position, how long she had served on the board. She answered each one comfortably. Then he placed a certified copy of my recorded deed in front of her. He asked a very simple question. When was the first time you saw this document? She hesitated. The room became completely silent. Even the court reporter briefly looked up before continuing to type. After several long seconds, she finally answered, but before our attorney moved to his next question, he reached into another folder, pulled out a printed email with her name on it, and slid it across the table toward her. The timestamp on that message would become one of the most important pieces of evidence in the entire lawsuit.